Hey, ladies and gentlemen. We're going to continue on, even though I'm not there. I'm going to put these um, lectures together this way so that we can keep going and we're not just wasting class days, and that we can be assured that, we're still doing what we need to do. And so I'm putting together a lecture today so that you are able to keep going with your notes. So um, take a few minutes, just get your stuff together. I'm going to um, pause a little bit and let you guys get all your stuff together, and then I'm going to start here in about 30 seconds. Okay, so I think we've got enough time to get everybody's stuff ready to go. So yesterday in class, you were filling out the form that got lost on Monday for the Stella Liebeck McDonald's hot coffee case. And so you filled that out. I have 12 submitted. I'll leave that open until probably tomorrow morning, Thursday morning, and then I'll go back in and grade those. Um, Make sure you do get those done. So just refresher, this was a civil case. We talked, one of the slides I probably didn't get a chance to show you was the effect of the degree of the burn. So when they were saying that they were serving the coffee at 180 degrees, the approximate burn time for third degree is instant. So even if we go over here, 154 degrees liquid temperature, instantaneous, but it's going to take a second to penetrate to that second and third degree. But I think this is even a better example of this. Um, when we look at different types of burns. So we have a first degree burn, um, a sunburn, just a mild sunburn. Um, that's what we're looking at. When we get into the second degree, we may start to see some blisters. We might see some skin peeling. Um, Again, sunburns. When we get into this third degree, and this is where Stella was, the burn had gotten so deep that it was nearly touching the tissue and the muscle. If it had gone fourth degree, it would have taken it right down to the bone. But she was literally, there were places where there was bone visible. So they know that she had a severe, high level third degree burn. Okay. Um, I don't know. I doubt if in the videos they showed this. I'm going to show you um, an image of her burns. And I will tell you, this is an image that is hard to see. And if you don't do well with medical or cuts or blood, this is not an image you want to see. So, if we remember correctly, the coffee pooled into her lap. She had sweatpants on, and it pooled into her lap. So it's the sweatpant material soaked up that coffee and held it to her skin even longer. And so, obviously, the place that she's going to be most severely burned is in her inner thighs. So, if you do not want to see this picture, I'm going to ask that you put your heads down now, close your eyes. I'll tell you when you can open them again. So, I'm going to show the picture now. As you can see, the burns were unbelievable. And if you want to, you can come back. That picture's over. Um, it is an incredible, absolutely incredible image to take in to show what happened in that instant moment. So I also went and I looked for some information about a little bit beyond and a little bit above with the money she had gotten. And so I went and I found the company admitted if customers were unaware that they could suffer third degree statement, blah, 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 blah. The jury awarded her $200,000 in compensatory damages. Compensatory is they're compensating. They are paying them for something, paying them for medical bills, paying them for lost work, paying them for something that happened. This amount was reduced to $160,000 because the jury found that Liebeck was 20% at fault in the spill. Remember, in a civil case, you don't have to be beyond a reasonable doubt. It's just the preponderance of evidence. Was her spilling the coffee part of the reason that she got burned so badly? And the answer is yes. It wasn't entirely on McDonald's. The jury also awarded Liebeck $2.7 million in punitive damages. Punitive is punishment, which, as you saw in one of the videos, was equal to 2 days' sale of McDonald's coffee. Now, in the post-verdict investigation, after the verdict was reached, the decision was reached, found that the temperature of the coffee at the local McDonald's had dropped to 158 degrees Fahrenheit. So they actually did change their behavior. Because of that, the court went back and reduced the $2.7 million that she was receiving in punitive damages and dropped it to $480,000. When we looked at that case, it wasn't even, I don't even know if I've ever seen where it tells that the money that she received was enough to pay for her medical bills. So, unfortunate, unfortunate. All right, so let's see where we've gone and what we've got yet to do. So we've done a lot in here. We have looked at laws as they are state, national, and city, how they are identified as act, statute, and ordinance. We looked at vague laws, Little Falls case, what society looks like with no laws, purge. We did a comparison of criminal and civil, and we've done and our next step then is bubble 6, and that is the one where we're going to look at different levels of crimes. So it's pretty consistent when we look at laws across the 50 states, looking into the federal government as well, that we have matching levels of laws where states have felonies, misdemeanors of some sort. But what is not in all states is that not all states have the death penalty. So if we look at this diagram, we see a lot of states that have gotten rid of the death penalty. Minnesota got rid of the death penalty. Let me go back and I will just check with you right here. (1911). That's what I thought. The death penalty was abolished by the legislature. It was it's pretty crazy. It was a botched execution. Marks an occasion in Minnesota history. 1906, was hanged for the murder of 2 people. His execution was botched, and his death led to Minnesota abolishing capital punishment. Yeah, absolutely crazy. So we haven't had it. I don't know if we've ever had really any attempt to bring it back into Minnesota. Other states that are in red, they have the death penalty. What moratorium hiatus means is, say, for example, right here, the governor of California, under his administration, because he believes it is cruel and unusual punishment, he has given a moratorium on the death penalty, meaning there will be no executions carried out while he is in office. So they still have the death penalty, but as long as he's in office, nobody will be executed during that time period. All right, so we're going to start with the top one, and that's the most serious. That's our felony. This is the law, the classification of laws that could lead to somebody being incarcerated. Remember last week I told you I used the term incarcerated to reference loss of freedom. So a felony conviction could lead to more than a year in prison, all the way up to life without parole. Okay, that is as close to the death penalty as we can get here in Minnesota, is life without parole. So, and minimum is a year in prison. I've also seen in this one, there's fines that go along with it. And I don't know if they set a maximum on fines, but I have seen Byron Smith. When he was sentenced to 2 counts of life in prison without the possibility of parole, and he had a $60,000 fine. Now I can show you how that paying that fine is going. Let me pull that up for you once. All right, so I'm going to pull up some information I found on Byron Smith. And when I'm looking at this, it's less than what I thought it was. I think they've had some changes in this. But anyways, I went into public access criminal records, and this is Byron Smith's from November 20, November 26th of 2012. So at that, the incident took place. Excuse me. So he is life without release. Okay, 2 counts of life without parole. 2 counts of second-degree murder. They didn't add anything on because it's a lesser offense. And so if I go into the case details, and this is what I always think is really cool that we can have access to, and anyone has access to this, is as of this morning, he still has $37,982.27 to pay in that fine that was waged against him. This just goes through who was involved, who were the attorneys, warrants were issued. His initial appearance was $2 million. His cash bail was $200,000. In Minnesota, you have to come up with 10% of the total being total amount of your bail. So if he was being bailed at $2 million, he had to come up with $200,000, and he did. And then it goes through in detail everything. And when I say it goes through everything, he paid an additional $50,000 so that he could, that was with conditions. This was no contact with the victim or family, do not leave Minnesota. These are requirements in addition to being released until the trial. And it just goes into crazy evidence. And so when we look, we actually have the ability to look at certain documents. Now, appellate court opinion, I don't even know what this is. So I'd have to go through that in a lot more detail to figure that out. Let me go back. I hope I didn't. I'm just going to keep going down because it's really... So when individuals are in prison, they can work. And this is the side that says, as of this day, this is how much he owes. I thought it was 60,000, but it must have been around the 40,000 mark. He's only paid $2,900 towards that amount. Now, you can work in prison, you just don't have to. And so when you do work in prison, the amount you're making, and I don't know if I can even find that. What do inmates in Minnesota make working in prison? Pay range is anywhere from 25 cents to $2 an hour. And so there are inmates out there, they'll say, I'm not doing anything. I'm not going to work for that. I'll just sit around. And there's nothing that says they have to. So you see that there's a lot of collection agencies are pulling money from him. They're not just asking for it voluntarily. And so there was a reduction. It's kind of a mess. So you get a chance to see that there is a fine with this. But anyways, moving on. One of the things I want you guys to know is that 95% of all cases are addressed in a plea agreement, meaning the prosecution and the defense find a happy medium so that the case doesn't have to go to trial. Because there's always that chance for both sides that it doesn't work out for them. So if they go to trial and the defendant wins, that means the prosecution has a loss on their side. If the prosecution wins and the defendant loses, the defendant has penalty and punishment. But if they come together in a plea agreement, let me pull this up. If they come together in a plea agreement, then the defendant gets less than what he or she could have if they hadn't agreed to a lower charge, and the prosecutor is given a guaranteed win in this case. So this is the key here, is only 5% of cases go to trial. And our criminal courts are backed up, and that's only 5%. All right. Now, when we talk about felonies, because they are the highest crime in Minnesota, there is an intense process that goes with it. Anybody who has been accused of committing a felony, murder, manslaughter, criminal sexual conduct, first, second-degree burglary, robbery, amount of money stolen is over $10,000. You're getting the idea. These are the high crimes. These are the big ones. Arson. You stole someone's car. I'm going off track. Every one of those people are going to have to submit to an arraignment. Now, an arraignment is a formal charge. It's the actual, and I'm going to add a few things into here. The arraignment is the formal process of hearing the charges directly from a judge. Okay, it's a process. It's part of the process. Okay, so it's formal. They'll stand in front of a judge, and the judge will read to them, this is what you're being charged with. Now, we're going to use that term again. Charges, you might hear the word indictment. Indictment is just a charge. So these terms get interchanged, and then they start to get kind of confusing. Once the arraignment has taken place, then the plea negotiations can start. Then we can start seeing if the defense and the prosecutor will be able to find some sort of happy medium. This is to avoid a trial. Trials are incredibly costly. I am aware of a former student who had an assault charge, and his attorney and the case didn't even go to trial. It was a case that pled out. The student wasn't happy it pled out because he wanted to go to trial because he thought he was in the right. He wasn't. And his attorney fees were over $6,000, and they never even went to trial. The attorney that worked with him said that if he had gone to trial, it would get closer to $16,000 to $20,000 to represent him in a actual criminal trial. If there's no negotiations, okay, the defense and the prosecution come together and they can't find a middle ground, then the case goes to trial. Now, felonies are going to be with somebody for the rest of their lives. They don't go away. And when we start looking at what a person goes, commits a felony, serves his or her time, comes back out in society, and is being asked to become a functioning member of society, there are things that get lost in the process. They are not allowed to vote. They may have employment issues where every time they apply for a job, there's that box on, and let me just see if I can find it. Okay, so I just went in and I just typed in application, have you ever been convicted of a felony? And a whole bunch of them popped up. What I find interesting is this one right here, where it says, have you ever been convicted of a crime? That opens a person up big time, because now it's not just saying felony, it's saying, have you ever been convicted in this one, convicted of a misdemeanor, convicted of a felony. So applications do it differently. Have you ever been convicted or pleaded guilty? I don't know what that's kind of. Yeah, see, there's the convicted of a crime again. Let me see what this. Have you ever been convicted of a felony? Yes or no? Please explain. Well, I always have students will say, why would you tell them the truth? You guys have seen how easy it is for me to go and do a background check. They're going to do background checks. And if you lied on your application, you can guarantee you won't get a job at that place. In addition to those problems, people with felonies are going to have a harder time with money. They're going to have a hard time getting loans. They're going to have a hard time buying a house. They're going to be denied credit cards. I mean, they can come out and say, I've served my time. Why am I still in this position? The answer being, you have a felony on your record. Well, the felony was from 25 years ago. It doesn't matter. A felony stays on your record. And then the last one is for the rest of that person's life. They can never be in the possession of firearms. So we saw Kim Potter get released last week. She is a convicted felon. She cannot be in a home where there are firearms. If her spouse has guns on the property wherever they're at, and they find out that she is in a property and she has access to firearms, she could be taken back into custody as a violation of her parole. So it's really critical that they follow those steps. So again, felony is the top of the list. Next one is a gross misdemeanor. Now, you're going to see some things that are going to look the same, and I'll walk you through this. Gross misdemeanors are one level down. And when we look at gross misdemeanors, sometimes a gross misdemeanor comes from a felony being negotiated down. So the prosecutor goes in with a second-degree murder charge, and the prosecution comes in with a second-degree murder charge, and the defense comes in and says, we'll agree to second-degree manslaughter as a gross misdemeanor. Now that might be far-fetched, but getting the idea that a felony in the books can be negotiated down. So what changes when it comes to felony is 1 year up to life in prison without possibility of parole. Well, a gross misdemeanor is different. A gross misdemeanor it's up to 1 year. Okay? They cannot be incarcerated, loss of freedom, for more than 1 year. and they have a maximum fine of $3,000. Now, it can be both 1 year in prison and $3,000 fine. It could be a $3,000 fine and 1 year probation. It really does fall on the judge. Now, what you're seeing here in the rest of this is exactly the same as what I had in felony. Okay? So if you don't want to write it out again, you certainly don't have to. Okay? So they're going to go through an arraignment. There's going to be a plea negotiation to avoid a trial. If there's no negotiation, then they do go to trial. And some of the long-term effects of the gross misdemeanor, again, it's going to be employment. You know, I know people who have gotten gross misdemeanors, and the belief is the felony's the one that's going to restrict you the most. Well, that's actually not true. Gross misdemeanors are going to have similar effects to that, where people are going to have trouble finding jobs because this is on their criminal record. So, and they possibly can be denied firearms, depending on the crime. So if it's an assault, it's a robbery, it's something that is a violent crime that they were charged with, it's very likely that they could end up being charged or denied the right to own a firearm later in their life. So we've done felony, gross misdemeanor, and then we have two more. We have misdemeanor. Misdemeanor is low-level theft. It could be fifth-degree assault. It could be under the influence, public intoxication. And there's a lot of things. We're not talking murder and criminal sexual conduct. These are not the big ones. Stalking could be. So what is somebody facing if they are found guilty? They could be incarcerated for up to 90 days. Okay, up to 90 days. And the most that they could be fined is $1,000. And I keep putting this same one on there because somebody might get charged with a gross misdemeanor by the prosecution, and the defense comes in and says, we'll plead it down to a misdemeanor. But you see here, something else is different. Something else has been added here, and that's what's called a CFD, a continuance for dismissal. In some misdemeanor crimes, the prosecution may work out a deal with the defense, and they're not going to ask for a plea. Okay, they're not going to make this a legal issue at this point under certain conditions. Under certain conditions can be, let's see if we can find a good explanation of a continuance of dismissal. Continuance without a plea is perhaps the best resolution to a criminal case besides outright dismissal or acquittal. A CFD is an agreement between the defendant and the prosecutor. A typical agreement requires that the case be put on a shelf for an agreed upon amount of time, a year, and if the defendant follows the terms of the agreement and has not gotten himself or herself into any more trouble, then that case will be dismissed. The only right a person gives up is their right to a speedy public trial. So essentially what they're saying here is, I am arrested for a misdemeanor, and I'm standing with the judge in front of me and prosecutor and the defense, and the judge says, I understand there is a continuance for dismissal on the table, and both sides would have to agree, and then I would be told for the next 90 days, these are your conditions. Any problems here, and you make it the 90 days with no problems, then this case just goes away. So it's kind of like an incentive to pull it together. And then we have the last one. The last one is our petty misdemeanor. What we see in this one, there is no incarceration. The fine can only be up to $300. And in fact, this isn't even considered a quote-unquote crime. This is more of a moving violation, a parking ticket, a low-level speeding ticket, parking in a handicap zone. I mean, this is what we're talking about. These are petty, very unlikely that you'll end up even in front of a judge. I got one several years ago. I was in St. Paul. I knew my meter was running out, so I was going to my car. The guy's out there giving me a ticket. I said, I'm right here. I'm just leaving. I'm right here. And he says, well, you should have been here sooner, and gave me the ticket. And so I paid the ticket. Well, not really realizing it, when you pay the ticket, you are admitting guilt. And you can go to court, but if you end up losing and there are court fees, you'll not only have to pay the $40 for the fine, but you could be hit with the court fees that go along with it. So this one is also could be a continuance for dismissal. All right. So just looking at these in just another little way. Here's our felony, 1 year or over 1 year, or a maximum fine up to. This is some of the crimes we're looking at. Gross misdemeanor is in jail, one day shy of a year, $3,000 fine. Here's a couple of examples. DWI, second degree assault, theft. Misdemeanor, 90 days in jail, up to $1,000 fine. Driving without a license, simple assault, first DWI, which frustrates me, don't get me started on that, and theft of property less than $500. And then petty misdemeanors, what we just talked about. So if you need to go back and see any of these slides before that we covered, or go back in the video, just let the sub know and you guys can back that out. I'm not adding an assignment with this. This is all I was going to do today is just these notes. So for the remainder of the time, you guys can just sit quietly, and I'm hoping I will be able to see you on Friday. I didn't think COVID was going to be this bad, but man, it's been a rough one. So I appreciate all the patience and support, and we will be in touch. Thank you, guys.